So for the state of Nevada, and feel free to go ahead and make your appearances, please, in case 886127.
Good morning, Your Honor. Michael Gahan on behalf of Plaintiff, State of Nevada. Here with me in court, I have from the Attorney General's office, Mark Kruger, Raquel Fulgham, and Sam Feely. Also with me, Randall Jones from Kemp Jones, my co-counsel David Slade, Phil Carlson, Will Sykes, also from Claggett and Sykes, and Chris Churzo and Richard High, all observing. And also on the Zoom, sorry, I didn't bring my glasses. The squares are pretty small. Let's see. Anthony Walsh, Cindy Jing, Brian McMath, Dory Tesser, Matt Bush, Veronica Robertson, Brian Moore, Michaela Wheeler, and I think that's everybody. Apologize if I missed anyone.
Okay, pausing for a second in case anyone need to make another appearance. No? Okay, counsel.
Good morning, Your
Go
Honor.
ahead, please.
Colby Williams and Phil Irwin from Campbell and Williams on behalf of the defendants, and appearing with me at council table are Rachel Chung and Lauren Kaplan from O'Melveny and Myers. They have pending Pro Hoc Vice applications, Your Honor. And if I might, as a housekeeping matter, we have submitted 4 motions to associate counsel at docket numbers 120 through 123. And the state kindly has filed notices of non-opposition to those at docket numbers 128 through 131. They're currently set for hearing on the 27th of February. So if it pleases the court and you believe everything is in order, maybe those could be advanced today and granted.
Sure. Let me take care of that in a minute. Let me make sure you got all your appearances. Are you just observing or are you making an appearance on this one?
Oh,
Phil Irwin, Your
Mr.
Honor.
Williams introduced that.
Yeah.
Phil Irwin's also from Campbell.
Anybody remotely?
We have people observing, but they're not appearing.
Okay, no worries. Okay. As I've done in the past, more than fine to review, excuse me. Motions to associate. Yeah, we showed the documents. Brody was document 120, Kaplan 122, Hutton 121, and Petroselli 123. Non-ops were 128 to 131. The court had an opportunity to review those. And since you're requesting ADCR 2.23 to have them advanced today, there being already a specific non-opposition, the court can advance them to today. Court had an opportunity, obviously, to review each of those applications, and so the court is going to grant them in accordance with appropriate Supreme Court authority. Is that going to impact today's argument?
It doesn't, Your Honor. I'm going to be the only one arguing, but I do think it's important to point out a clarification. Ms. Chung's application is pending with the state bar. So of the 4 that you just approved, that includes Ms. Kaplan, but it doesn't include Ms. Chung yet, who's pending. So
Which I can't do until I have
right,
a motion.
I just wanted to clarify.
Yeah, no
I didn't
worries.
want there to be a misinterpretation of the record. She's just going to be sitting with me at council table.
The reason why I was asking if anyone was going to be arguing is because, as you
Exactly.
know,
I get it. We're gonna spare the
I
court
don't
that.
have,
this
no, I
time.
don't have proposed orders, so I couldn't review them anyway. And so I was just double checking. Okay. So those are granted, need to provide orders, EDCR 7.21, DC 31 inbox, in accordance with the administrative order, and to the extent that one of those applications not even yet before the court, I can't review it until I actually see it.
Understood.
But a friendly heads up, give us a courtesy copy so we don't have to go looking through the pleadings to try and find them for hearings.
That's right.
Thank you. Okay, so you all recall, bless you, this case has been, there is a media request. And so remember, since we have certain information, except that you think it's confidential, you need to let the court know in advance if I need to address anything specific. Otherwise, it's full public access, okay? Reminder to the parties in that regard. I double checked with my JEA. You all said you'd benefit from a special setting, but I don't think we ever got a notification of any time, which is why we set you at the normal 8:30 with the rest of our 8:30 business, because we never got, in the past, we've gotten some notification. Each side needs X amount of time, then we find the appropriate slot for you. So I'm gonna have to ask you how much time you do need, because you got set here because we never got any follow-up on a special setting or any time requests. So let's see what we can do, because I do have, so you can appreciate, another 8:30-ish matter. And then the rest of my morning calendar. Go ahead, please.
Sure, Your Honor. we didn't follow up on the special setting speaking for the defendants only because the court has heard some of these issues before. And my hope and goal would be that we're not going to need to take near the amount of time we did the first time we were here. So I would expect I can make my initial presentation in between 10 and 15 minutes.
Right, but as you know, it's 5 to 7 minutes unless you have
And
a
so-
designated special setting. And just in fairness to everybody else who
Sure.
patiently waits.
And
for
so
their turns.
I heard your instruction to my partner in that regard. And so I think I can, modify it to get within that time frame.
Also for the state,
Your Honor, Michael Gain for the state, I'm prepared to stick to 5 to 7 minutes, or as long as subject to court questions. And if Mr. Williams is granted additional time.
right, you all know, it's just we try and be fair to every single case and not, if we're gonna run long, we try and give people heads up and we just try and schedule as best we can.
I get it, Your Honor.
So, and it's the same courtesy you all like, so, okay, so let's go to defendant's motion to dismiss plaintiff's second amended complaint, document 108, plaintiff's opposition thereto, and defendant's reply thereto, as well. The op was 117 and the reply 133, and pursuant to a stick, it got extended. Okay, counsel, go ahead.
Good morning, Your Honor.
Standing or whatever argument you like, go ahead, please.
Yes, Colby Williams on behalf of the defendants, Your Honor. We're here again on a Rule 12b-5 motion to dismiss. And though we seek to dismiss the entire second amended complaint, our focus here today is on counts 3 through 6. Those are the common law claims for product liability, negligence, and unjust enrichment. Counts 1 and 2 of the second amended complaint, Your Honor, are the Nevada Deceptive Trade Practices Act claims. We recognize the court denied our motion the first go round on those. I just want to note for the record, Your Honor, that we did file a writ petition seeking to press certain of our arguments in that regard on First Amendment grounds, Communications Decency Act grounds, Section 230, and lack of personal jurisdiction. I'm not going to get into those today. I just wanted to note it for the record. Turning to the state's common law claims, Your Honor, the court previously dismissed these claims based on lack of standing and for independent additional reasons. We submit the court should enter the same ruling again this time, albeit it should be with prejudice, because we submit the state can't cure these defects. I'd like to start by making a couple overarching points. Your Honor, standing is a question of law. If the state lacks standing, then the claims all have to be dismissed. But even if the state can overcome the standing hurdle, the claims suffer from additional legal defects. Products liability, Your Honor, the question of whether something is a product is a question of law. Negligence, Your Honor, to demonstrate whether the defendants owe a duty to the state is a question of law. I bring this up because the opposition filed by the state takes some shots at us for spending too much time making legal arguments, but there is a very good reason for that, because the vast majority of the amendments to the complaint took the form of legal arguments and policy arguments. There are few, if any, new factual allegations in the second amended complaint. And that's important, Your Honor, because I would submit the state did not do what it was required to do, which was to provide you with new factual allegations to save the negligence claim and the unjust enrichment claim. Let me stop there for a minute. They didn't change a single word to those claims, not one word. With respect to the products claim, Your Honor, they've added legal arguments and policy arguments, which we'll explain don't survive this dismissal motion either. Now, what is the state's response to us when we raise the lack of new factual allegations? What the state tells you, Judge, is that by fixing the standing problem, they've simultaneously fixed the other defects with those claims. And most respectfully, they have not. Standing is not synonymous with stating a viable claim. If it was, Rule 12b-5 would be a dead letter as long as the plaintiff said, I have standing. And that, of course, isn't the law. So by saying you've got standing, which we don't agree with, that doesn't mean you've established that the TikTok platform is a product. It doesn't mean you've established that the defendants owed a duty to the state. And it doesn't mean you've shown or alleged that the state conferred some duty on some benefit on the defendants. So let's jump into lack of standing. Your Honor, it's the state's burden, as you appropriately found in the prior order. It's a question of law. And the state tells us it has the ability to bring these claims based on the doctrine of parens patriae. We discussed this previously, the first go round, Your Honor. That doctrine has never been recognized as a vehicle by which the state can pursue common law claims for money damages on behalf of individual Nevada citizens, particularly when those Nevada citizens can pursue their own relief. There isn't a single statute that authorizes it. There isn't a case that authorizes it here. And we submit the state had to at least come forward with one of those or both. Previously, we argued, Your Honor, that the state had to have a statute that authorized it to bring these claims. It hasn't identified any such statute in the amended complaint. It hasn't identified any such statute in its opposition. Their position is they don't need to. Okay, well, at a minimum, certain cases find if there isn't a statute, at a minimum, you have to have controlling legal authority that authorizes you, the state, to bring these types of claims. Here, it would be a case from the Nevada Supreme Court or the Nevada Court of Appeals. Has the state given you one of those? No. The second amended complaint cites the Moore case and the Ryan case, both from the Nevada Supreme Court, but Your Honor, they don't address these types of claims. And importantly, both of those claims rejected the powers that the AG wanted to exercise in those cases. That's why, in the opposition, the state doesn't say a word about those cases anymore after originally citing them in the second amended complaint. What the state does rely on, Your Honor, is a U.S. Supreme Court case, Alfred L. Snap versus Puerto Rico. But that case doesn't help it either. That case is not about money damages. It is about seeking equitable relief. And the Supreme Court went through the history of the parent patriae doctrine, and it said a couple things have to be present in order to assert it. First, the state has to assert an interest that is apart from the interests of the particular private parties that are claimed to be injured, apart from. Second, there has to be a quasi-sovereign interest. The state's opposition focuses on the second. We've got a quasi-sovereign interest. We have to protect the welfare of the state. But Your Honor, court after court after court that has looked at that argument says that may satisfy what's a quasi-sovereign interest, but it doesn't establish an interest apart from the private individuals that are claimed to be harmed here. The state never does that, and neither do any of the other cases it cites. The Bank of America case, as a standout example, supports what we're telling you. In that case, the state was able to pursue the claims because the Deceptive Trade Practices Act statute authorized it. There was the statutory authorization. It doesn't exist here. There's no standing for another reason. Parents patriae standing requires a finding that the individuals cannot obtain complete relief through their own private suit. What does the state say about that? Not a word. It never contests that the private citizens of Nevada that are allegedly harmed here couldn't bring their own claims. They can. Other citizens have brought these types of claims on their own. The MDL case in the Northern District of California that we have cited to you, and the joint proceeding in California State Court that we have cited to you are examples of private citizens bringing claims based on the alleged harm that is the focus of the second amended complaint. There's no standing here. All these claims have to be dismissed. They need to be dismissed for other reasons as well. Product liability, Your Honor. Threshold question, is the TikTok platform a product? You looked at this before, you found that it wasn't. And we submit that that was the correct finding. We have the Nevada Court of Appeals in Schuler telling Nevada courts what they have to look at to determine whether something constitutes a product. You must look at the restatement section, section 402A, and specifically the policy objectives and the state. This is important. The cases that interpret that section. This court did that before. I'm going to talk about doing it again here in a moment. The other thing that the Schuler case tells us is that you may look at other sources. The third restatement is something this court looked at in its prior order. Both the second restatement and the third restatement focus on tangible items, Your Honor. The alleged harm here comes from something intangible, user content, or design elements that deliver user content, not tangible items. But you don't need to just take my word for it. In compliance with Schuler, we've presented you a number of cases on page 9 of our motion that have looked at whether online platforms constitute products for products claims, and they all said no. What does the state say about those cases? It says we addressed those the first go round in the first motion to dismiss. But Judge, respectfully, we won on this issue before. So whatever the state said before about those cases wasn't persuasive, and we submit it's not persuasive now. The only case that the state gives you on this topic is Lemon v. Snap. And that should sound familiar to the court because we talked about that the last time we were here. Lemon v. Snap is a very narrow holding. The Ninth Circuit there said that the Communications Decency Act didn't bar a products claim. Fair enough. But the court never reached the issue whether the platform itself or the design element in that case constituted a product. And there's a good reason for that, because the Ninth Circuit told us the district court never even reached what state law applied. So it certainly didn't get to the issue of whether it was a product under that state law. So the Snap case doesn't help it. What does the state do? Let's look at policy objectives. Okay, well, Your Honor, products liability doctrine is designed to address obstacles to recovery that exist with other causes of action. But we submit the objectives aren't met here. There's privity between users and the defendants. Okay, there isn't difficulty identifying some remote participant in the chain of alleged wrongdoing who did what, because the alleged wrongdoers, and we dispute there's any wrongdoing here, but they're known. So those types of issues that justify product liability doctrine don't exist here. And what Schuler tells us is that if the objectives aren't met, then the doctrine shouldn't be applied. And that's certainly the case here. I'm going to quickly wrap up with negligence and unjust enrichment, because I think that, Your Honor, they're pretty easy to deal with. The state tells you in its opposition, starting with negligence at page 11, that the only reason you dismissed this claim last time was because of lack of standing. And Your Honor, that's just not true. Respectfully, pages 12 and 13 of your order, and I'm quoting here, the state has not alleged any facts indicating that defendants owed a legal duty to the state for negligence purposes, end quote. So how did the state fix that problem that you identified in your order? The answer is they didn't. They didn't change a word, Your Honor. It's the same claim today as it was back in the first amended complaint. It should be dismissed for the same reasons. On top of that, we could argue that there's no special relationship here between the state and the defendants, or even the users and the defendants. What does the state say about that? Nothing. So that's another reason that the negligence claim should be dismissed. And finally, unjust enrichment, Your Honor. The state again tells you that the only reason you dismissed this last time was lack of standing. They tell you that at page 19 of the opposition. Absolutely incorrect. Page 13 of your order, quote, nor has, and I'm bracketing here, the state alleged that defendants were unjustly enriched at the state's expense. Okay, how did the state fix that problem?
Whoever's phone is going off. Oh, okay.
We'll let that one go.
She's the boss.
Absolutely. You're not going to hear me say anything. Your Honor, real quickly, how did the state fix that problem? Once again, it didn't. The unjust enrichment claim is identical to how they pled it the last time. And so it should fail for the same reasons. On top of which, the state never addresses the undisputed fact, in fact, the admitted fact in the complaint, that the relationship here is governed by a written contract. They admitted at page 60 of the second amended complaint. The relationship between users and the platforms is governed by a written contract. If there's a written contract, you don't get to pursue equitable relief in the form of unjust enrichment. I'm happy to answer any questions that the court has.
I'm in no way expanding today's case to a case I might have had last week. But since one side that's here in court today had the benefit of knowing the arguments that came across in that other case, and the other side may or may not, I don't know if people were observing, it's a public courtroom, people are more than welcome to do so, okay? I'm going to ask you a question from Schuler, okay? So that we're on the same page.
Okay.
The paragraph in Schuler that this is as to the product's liability question, okay? Accordingly, we conclude that a case-by-case approach, and it's partly quoted in my prior order, I'm gonna read the
Oh,
whole
yeah.
paragraph though.
Sure.
Okay, accordingly, we conclude that a case-by-case approach is a superior methodology because it is versatile, permitting courts to analyze each case individually and adjust to changes in technology. Yes, I'm focusing on the technology. And because it is consistent with text and purpose of section 402A. Period. Therefore, when determining whether an item or instrumentality is a product that falls within the scope of strict products liability, courts must, and must is italicized, apply section 402A of the restatement, including the public policy objectives of the doctrine as well as the relevant precedents interpreting section 402A. You've already addressed most of that in your oral argument, but where I'm going back and kind of just going to focus is my question on the implications, if any, or how one should be reading. I think I said I read it 15 times already for last week, and yes, I've read it more times between then and now. It's whether that the analysis in Schuler by our Nevada Court of Appeals in a published case, so fully presidential, nobody seems to dispute that, and saying that you should adjust to the changes in technology if that makes it distinguishable from most of California, right? Because while lots of courts follow restatements, whether they're following restatement 2 or restatement 3, and restatement 2, obviously older, so couldn't have had social media platforms at its time. But what's your thoughts on Schuler's viewpoint on whether or not something outside of a tangible product should be included within the case-by-case analysis? Versatile, permitting courts to analyze each case individually and adjust to changes in technology.
Sure, Your Honor. And I think the court got this right the last time because you acknowledged this very point in your order and acknowledge, because that's a big focus of the state's opposition, right? Is it's got to be case by case, adapt to technology. And I'm not arguing with what Schuler says at all, or that it applies, or that it requires myself as an advocate or the court to look at those things. And I think we all did that the last time. So what Schuler says is you've got to look at the policy objectives, and we've done that. We talked about why we don't think they're met here. And you also have to look at precedent, which is what I think gets to the heart of the court's question, which is there have been other courts that have looked at the restatement, policy objectives, and applied it to online platforms and have found that they aren't products. And so I think they've taken all of those considerations when making those rulings. So I think in terms of considering whether technology, we've cited to you, like there's another SNAP case, for example, the Zinc case from 2023, where it said the online platform is not a product, it's intangible. Now, are there examples where an intangible product, you see the state rely on the electricity example that's in the third restatement more so? Yeah, some courts have looked at that, but the social media case, the state court proceeding that I've cited to you, it's the joint proceeding in State Court of California, looked at that exact argument. Are there times where a service could qualify as a product? Maybe, but we submit that's not the case here. It's got to be analogous to a tangible item or a tangible product, and that doesn't fit the bill here. This court looked at that issue. It also looked at the analogy to electricity and said it doesn't fit because while it may be intangible, it doesn't become a product until it's delivered across the threshold into the home. Everyone uses electricity the same way, right? It's being delivered to you, and the product defect typically arises if there's a big, a high voltage incident or a deficiency of some kind that causes there to be a disruption. But everyone uses the TikTok platform or other social media platforms differently. So while it's being delivered as a service and it's intangible, people aren't using it the same way. And so I don't think when you look at technology and these other things that are referenced in Schuler and in the research, I don't think it changes the analysis.
So then the follow-up question, because the state's going to point it out, is then what, if anything, could a TikTok be liable for? Not saying you are not saying engaged in any inappropriate conduct or promotion at the stage. I'm just saying what I know How does one characterize it?
The
Or does-
deceptive trade practices claim survived our first motion, Your Honor, so it's not like they're completely out in terms of the ability to pursue causes of action. I obviously don't agree with that, but I mean, if the argument is going to be, what if anything could we sue these platforms for? Well, there's just, I mean, those two examples stand out in this case specifically. We have arguments that we think should result in a different result, but I'm not arguing those here today. So it's not as if these providers, I don't want to say that they're immunized, because I do think CDA Section 230 does provide immunity for certain of these claims, but it's not as if there aren't causes of action out there that have survived the initial motion to dismiss.
Appreciate it. Thank you so much. Counsel of the State, go ahead, please.
Yeah. Your Honor, Michael Gann for State of Nevada. I'm going to start with standing. This is in our briefing, but I agree with Mr. Williams that, at least from what I heard, the only real issues are standing, whether it's a product, and then I disagree with the last 2 points about duty and benefit conferred under unjust enrichment. Those two do tie into standing, and I'll address that just real briefly. The court's order on negligence said something to the effect of, and I don't have it in front of me to read, but it said the state hasn't identified a duty that TikTok owed to the state. Well, the state is asserting that TikTok owed a duty of reasonable care to the TikTok users who are Nevada residents, and so it ties into the standing. Unjust enrichment, the court's order says the state hasn't identified a benefit that the state conferred, that the state conferred on TikTok, but the state is alleging that Nevada residents have conferred a benefit on TikTok. And so those two things do tie into standing, which is where I'm going to start. The first thing I want to address, Your Honors, I heard counsel say 2 different times that the state has not identified a statute to show that it has standing to pursue common law claims of product liability, negligence, and unjust enrichment on behalf of its residents. I think I heard that 2 separate times, and it's alleged or claimed in TikTok's briefing. It is absolutely false. It is, and just so we're clear, the parens patriae standing is a common law doctrine for the state to pursue claims on behalf of its citizens or groups of its citizens. A statutory grant of authority is separate and apart from parens patriae. And the Frito-Lay case from the Ninth Circuit in the 70s that TikTok relies so heavily on said that the state did not have common law authority. And right at the end, it actually said, instead of judges shooting from the hip on this issue, states should legislate if they want to have this authority to pursue common law claims. And sure enough, Nevada did in 1997. And this is in fact in the very first paragraph of the amended complaint. It says the state of Nevada, by and through Aaron D. Ford, Attorney General for the state of Nevada, and Ernest Figueroa, consumer advocate, files this complaint on behalf of the state under their express statutory authority provided in NRS 228.170, 228.308, 228.380 sub 1, and 228.390 sub 1A, as well as the state's parens patriae authority, etc. Well, what do those statutes provide, Your Honor? I would strongly encourage the court to take a close look at those statutes identified in paragraph 1 of the amended complaint. 228.380 sub 1 says, except as otherwise provided in this section, the consumer's advocate, who is Ernest Figueroa, may exercise the power of the Attorney General in areas of consumer protection. 228.390 sub 1A the consumer's advocate has sole discretion to represent or refrain from representing the public interest and any class of customers in any proceeding. And then 228.308, also in paragraph 1 of the complaint, defines public interest to mean the interests or rights of the state of Nevada and of the residents of this state, or a broad class of those residents, which arise from the constitutions, court decisions, and statutes of this state and of the United States, and from the common law. So, consistent with cases cited by TikTok, we have express statutory authority for the Attorney General and or the consumer's advocate to pursue common law causes of action on behalf of the residents of the state of Nevada or any broad class of those residents. That is exactly what this case is. This is a broad class of Nevada residents, primarily consisting of Nevada's children and their families. So I think that express statutory grant of authority to pursue these common law claims puts to rest the issue of the state's standing to pursue these common law claims, counts 3 to 6. Now, I'll briefly touch on Prince Patriae, but it's briefed in the state's opposition. However, I want to make clear the SNAP case does not say that damages claims can never be brought on behalf of the residents by the state. In fact, I would encourage, and this is in the state's complaint, we put it right in there, paragraph 35 is a quotation to Nevada versus Bank of America from 2012. And that's the Ninth Circuit Court of Appeals decision related to the mortgage crisis. And there, admittedly, those were claims under the Nevada Deceptive Trade Practices Act. But the question was whether there was federal jurisdiction or not. And ultimately, the case was remanded at the direction of the Ninth Circuit. But the court there in Bank of Nevada recognized that the state had a strong quasi-sovereign interest in the protecting the citizens and the economy from the issues caused by the mortgage crisis. And they said there was, quote, no doubt that the Attorney General had authority to bring these claims and that Nevada had a specific concrete interest in eliminating deceptive practices. So they identified a separate state interest, and that's what the Prince Patriae cases required. The state can't simply pursue individual causes of action on behalf of its residents. It has to have separate and apart a state, quasi-sovereign state interest. So in the health, well-being, whether it's physical or economic. And so that's the SNAP case, also recognized in Nevada versus Bank of America. And I think the key point from Bank of America is it says that the state's sovereign interest in that case was not diminished by the fact that the state had tacked on a claim for restitution. So the claim for money damages on behalf, restitution on behalf of the residents of Nevada did not alter or diminish the state's sovereign interest to pursue those claims and protect the state and its citizens. And it says, quote, that individual consumers may also benefit from this lawsuit does not negate Nevada's substantial interest in this case. That's the situation here. We have claims on behalf of the state of Nevada and its residents being pursued under the statutory authority, but also the common law Prince Patriae authority. I don't even think we need both. The statute is so clear that I don't know that the court even needs to reach the, I would say, admittedly, a little bit complicated Prince Patriae standing realm. At least it's more complicated than the statute. So happy to answer any questions on the standing, Your Honor, but I think that carries through to all common law counts, which are counts 3 to 6.
Okay, so I do have questions, 2 questions, actually. One, are you contending that there's any case under NRS 238? I'm just going to and the subsections you specifically cited, right, that sets forth the scope of what either the consumer advocate or the attorney general, since you represent them both, right, through the state of Nevada, can and cannot pursue. I mean, I didn't see that either side really cited to me anything that was a 228.308 public interest defined, right? That any court has previously found what actually is the public interest in the scope of the AG and the consumer advocate.
I'm not aware of a published case that would bind this court from the appellate level decisions. What I'm told from my client is that they use these statutes all the time in district court, but that's clearly not binding on this court and how the Attorney General's office operates under these statutes. And the consumer's advocate, but I do understand that the state Attorney General's office relies on these statutes on a regular basis in pursuing claims that they find worthy of their time and limited resources. But in terms of a binding decision that would interpret these, I'm not aware of one. If there was one,
I just assumed if there was one, someone would have cited
someone would have cited it.
or
Certainly
even
would
an
have.
informative one would have inadvertently been attached to the end, right? Okay. So my next question, and no surprise, how do you tie this into unjust enrichment, right? As an equitable claim.
Sure. Well, unjust enrichment is under the common law, although it is an equitable claim, not a legal claim. I understand that, but it's certainly from the common law. And so with the public interest definition permitting the consumer's advocate to pursue common law claims on behalf of the residents, that's how that ties in. And the allegation in the cause of action is that Nevada's residents, including the young users as defined in the complaint, have conferred significant benefits on TikTok to the tune of substantial amounts of money. And that's in paragraphs 426 to 431 is count 6. But unjust enrichment is a creature of the common law, certainly not.
I'm appreciative, it's a creature of the common law, but that's the reason why I was focusing on its equitable component. You're saying the state of Nevada can assert equity one level, I don't want to call it one level down, just let's just say upon a broad group rather than itself.
Yes, based on the statutes that I went through, 228-308, public interest defined, the consumer's advocate can pursue any claims on behalf of the residents of this state or a broad class of those residents arising from the common law, and that includes unjust enrichment. And I think it ties into the Bank of Nevada language that I quoted. The fact that the state in that case tacked on a restitution, a request for restitution, didn't diminish the state's interest. Restitution is essentially the remedy for unjust enrichment, or at least analogous to the remedy for unjust enrichment. So
what would be the restitution here? I mean, walk through right to the end, right? In order for it to be a viable cause of action, it actually at the end has to have something that can be put into a judgment, whatever type of judgment it is, right? Either it's a monetary judgment, a declaratory judgment, equitable restitution, etc. How does that one walk through?
sure, and I don't have all of the paragraphs memorized from the amended complaint, but I guess one comment before I answer the court's question: we are here on a 12b-5 buzz stew. No facts could exist to support the cause of action, but in essence, the state's allegations are that TikTok intentionally designed its product to be addictive to children, to monopolize their time, get children to log on more, stay on longer, and take the children's time. And that time was then monetized by TikTok. So the benefit conferred was the untold millions of hours by Nevada residents spent on the TikTok platform that they would not have spent but for TikTok's dangerous design features that addicted the children, their misrepresentations about the safety of their product, that had TikTok been forthcoming about the known dangers and mental health potential issues of using its platform to such a degree for children then parents, guardians, others, maybe schools would have done things differently and reduced the amount of time that children are on these, on the platform, on the product. So the benefit conferred is the amount of time, and it would be unjust for TikTok to retain all the benefits of all the untold millions of hours spent on its product, based on the inequitable conduct that they engaged in to first design the product and lure children into using the product when it was not safe for them to be using.
So what would be the remedy was really the question, right? It's just like, it's a standard question, right?
Sure.
On a motion dismissed, you gotta look at the elements of the cause of action. And one of the elements is damages in whatever form it may be, whether it's a restitution damages, whether it's declaratory relief, determination damages, something. That's
Sure.
my question really is simply, I appreciate the argument, as you know, I've read through all of this multiple times. I'm just trying to get to, I've got to analyze for a 12-week 5 is, does the complaint assert all of the elements of a cause of action, which would include the unjust enrichment, which is why the court was asking that question.
Sure, Your Honor, in terms of the potential damages, we are at a 12B5 stage. I think the most obvious one would be disgorgement. So any profits related to the time spent by Nevada children on the TikTok product should be disgorged from TikTok. And if you look at count 6, Your Honor, paragraph 428, young users in the state of Nevada have conferred a
Hold
benefit.
on a second,
I
because
apologize.
remember, I don't have a courtesy copy of your amended complaint, so give me a quick second. Remind me exactly the date it was filed,
Sure,
quicker than me.
November 15th, 2024.
It's- And you're not reading anything that's in the sealed portion, correct?
I do not believe so. And I just, I heard the court's comment earlier. Hopefully anything I've said today was not sealed. I've not tracked that closely, and I trust Mr. Williams would jump up and say something.
And no worries, as you know, the court needs to balance those interests of the public. It's a public courtroom. Want to make sure when court has public access, but at the same time, I do have a specific confidentiality stipulation from you all.
It's certainly not been my intention to
No.
comment on anything sealed.
I presume someone would raise it if it was an issue.
Your Honor, I'm not aware of anything, so I'll keep a close eye on Mr. Guy.
I'm not in any way, it's the same thing I say in any of the cases in which I've got it, because sometimes it's easier for the court to focus on it versus sometimes parties are focused on some different things. Counsel, can you go back to the paragraph number, please?
Sure, 428 on page 106.
1 second. Appreciate this. Gonna take me a few clicks to get down to it. Okay, 426 on page 106, count 6 unjust enrichment. Go ahead, please.
Sure. Paragraph 428, young users in the state of Nevada have conferred a benefit on defendants in the form of being a monetizable audience, providing not just an opportunity for defendants to sell advertisements, but also for defendants to acquire sensitive and valuable personal data associated with young users, as well as for all other reasons that defendants have described in a monetary value to young users. Paragraph 429, defendants knew of the benefits conferred. 430, defendants accepted the benefits conferred. And 431, it would be unjust to allow defendants to retain the benefits conferred without paying their reasonable value. So the state's position is that with the statutory authority to pursue common law claims based on the residents or a broad class of the residents, which clearly this case is brought on behalf of the Nevada children, and under the notice pleading standards and Buzz Stew, that the allegations in the complaint taken as true set forth all of the elements for an unjust enrichment cause of action by Nevada residents who have used, including young users defined in the complaint, who have used the TikTok product and conferred this benefit on TikTok. So it's not, maybe damages isn't the right term because we are in an equitable cause of action here, but I think disgorgement would be, and that's 431, that it would be unjust to allow defendants to retain the benefits. And that's a fact question. I don't know. Standing here today, I don't know what all the benefits were that TikTok gained. I don't know how they used all the data that they took from Nevada's young users. Certainly they sold targeted ads, but what else did they do with it? I don't know. But these are fact questions that aren't appropriate on a 12b5 motion. At this stage, I think the state has clearly met its burden to state a claim, and TikTok has not met its burden under Bus 2 to show that there's no set of facts that could ever support these causes of action.
Appreciate it. Thank you so much.
Okay, and then on negligence, Your Honor, I think the concept is the same. The duty is owed to the young users, and that's just looking at count 5. The state has alleged this duty. That's paragraphs 417 to 425. I know the court has other matters, so I don't want to take more time, but that's stated as well. Similar to the unjust enrichment, the state has stated a claim for relief under 12b5 and Bus 2 and the notice pleading standards. I did want to get to the product, Your Honor, and I'll try to keep it brief. But in terms of Schuler, the court is correct. Schuler encourages or requires a case-by-case methodology for determining when an item or instrumentality is a product. And item or instrumentality, those are very broad terms, and those are actually defined. We put those in our complaint. And to say that, I think I heard that no new facts were added. Your Honor, we added substantial facts on these issues. It's paragraphs 352 to 377, and then also 383 to 411, and 413 to 414. Those were added. And although we argued about the electricity analogy last time, those were not pled as facts. They are now pled as facts. And there is a detailed analogy in paragraph 365 about how the TikTok platform is similar to electricity. And I know we argued this in some form last time, but now it is alleged as factual allegations. We have, this is starting on page 91, line 5, line 4. Like providers of water and electricity, defendants can only deliver their TikTok product to users via a complex physical infrastructure, e.g. networking cables, cellular towers, servers, internet exchange points, data centers, and individual users' devices. Much of that physical infrastructure is located in Nevada. The point being that the TikTok product cannot be delivered in this state without TikTok utilizing physical infrastructure in the state of Nevada. TikTok is taking full advantage of Nevada's infrastructure and deriving a monetary benefit by doing so. Also, like providers of water and electricity, defendants closely measure how much of their TikTok product their users consume. And the more of their product a user consumes, the more data and attention the user pays for that product. It must be noted, however, that Nevada forbids using the restatement third of torts definition as a shortcut for avoiding consideration of the policy objectives set forth under section 402A of the restatement of torts, and that's from Schuler. So, Your Honor, I believe the factual allegations are sufficient to state a claim at this stage. This is 12b5, Buzz 2. These are very fact-intensive issues. I will point out that Schuler was at summary judgment, not motion to dismiss. So there, although the district court got reversed, at least the court had a clear factual record before it. And I don't know that the court, with the factual allegations that the state has before it, should be engaging in the case-by-case, fact-intensive analysis that Schuler requires without a clear factual record. The state has alleged sufficient facts to meet its burden under notice pleading, 12b5, Buzz 2. The party should proceed to discovery, and the court can revisit this at the summary judgment stage. I'm sure TikTok would want it revisited with a full record. And I will remind the court that this is from Schuler, that the directive from the Schuler court was that no matter what definition of product the court adopts, the courts must explain why their decision comports with the policy considerations, the three policy considerations articulated in Schuler. So the court can't just say product, not product. The court needs to do a detailed analysis. And at this stage, without a full factual record, like the Schuler court had before it, and those facts are discussed in the Schuler decision, and they mattered to the outcome. So I believe it's appropriate under Nevada law to allow the claim to proceed. The state has stated a claim for those, has showed why it has standing, and I would urge the court to deny the motion.
So I gotta pause you there. So
Sure.
are you contending that Schuler stands for the proposition that there can't be a motion to dismiss if there's an assertion of a product's liability claim?
No, not at all, Your Honor. My assertion is that the state has added dozens of paragraphs of factual allegations about how the TikTok product works, how it's delivered to people in Nevada, how it's used. It occupies physical space on people's devices. Hundreds of thousands, maybe more than 1 million people in Nevada have it occupying physical space on their electronic devices. So to say it is completely intangible, I don't think that's supported by the record, or at least the allegations. So TikTok is trying to draw a line between tangible and intangible. That is a question of fact, I believe, as well, based on the state's allegations. That seems like that's going to need expert testimony, or at least some additional factual information for the court to decide. I don't know that the court could say on a 12b-5 faced with these allegations in the complaint that TikTok is tangible or intangible. Whether that matters under Schuler or not, I'm not sure that it does, but that seems to be the line that TikTok wants the court to draw.
I'm kind of asking a little bit different question. What I'm hearing from you is that this court could not make a detailed analysis, right? Taking into the policy considerations under 402A, the second restatements as articulated in Schuler. So are you going one step further to say that by definition, that means that the court can't address this issue on a motion to dismiss stage? Because as you pointed out, the court's supposed to make an analysis one way or another. So if you're saying on the one hand, court can't do it, but yet it's required to do it by the Court of Appeals, I just wanted you to please reconcile what you're saying the court can and cannot do, because that came across a little unclear.
And I apologize for not being clear on that. No, I think the process that the court would need to follow under Schuler and under Buzz Stu is go through the state's second amended complaint, find all factual allegations bearing on this issue, and stack them up against the Schuler case-by-case analysis and the policy considerations, and the state's allegations all accepted as true, and feed them into the Schuler and restatement analysis and go from there. The only caveat to that, Your Honor, is, this is a notice pleading state. And so the state is entitled to some discovery. We don't know exactly what their product does, what it doesn't do.
I need to pause for a sec because I'm really trying to hone in on kind of a specific point here, right? Everyone acknowledges this is a motion to dismiss. No one's asked this court, nor is this court intending sua sponte to turn it into an MSJ. Realize I have the opportunity to do so. I'm not. I can't see on this type of case how it would be appropriate, so I'm not going to do it. And nobody's asked me to do it, so I don't have that issue there. So it's a straight 12 standard, right? But you are correct that the plain language of the factual situation, sure, everyone agrees, is a summary judgment, right? So the above ground aspect of a billboard, okay? Not the below ground pylon supports. So yes, it says it's got to do a detailed case by case analysis. I've read it. It's in your brief. It's obviously plain language. Everyone's cited to it. So what I'm trying to get the state's understanding just the state's position on this specific point is, are you saying taking the Buzz2 analysis, I need to deem all your allegations as true, and then I still need to do a factual analysis under Schuler that whether or not deeming all those are true means or because it's a Buzz2 analysis, I have to deem them all those allegations as true. So by definition, it meets Schuler's policy considerations, regardless of whether the court takes potentially the restatement third in certain circumstances, which it still can take because it's not formulaic approach, right? It's a case by case analysis, including technology, right? So that's the point. I'm just really trying to get you to clarify. I understand your generalized position. It's in your brief. I've heard it. Okay, appreciate it. I'm just trying to get really fine tuned on that point is what are you contending the court can and cannot do in a motion to dismiss stage? Because you're the one raising that issue.
Sure, Your Honor, I think the court has that right. Under Buzz Stew, the court needs to look at all the state's factual allegations bearing on whether TikTok is a product or not, whether this item or instrumentality. I think it's clear it meets both definitions of item or instrumentality. And the Schuler court says when a district court is deciding whether a particular item or instrumentality is a product for purposes of Nevada's product liability laws, then it must do X, Y, and Z and apply the case-by-case approach, the policy considerations. And in my reading of Schuler, that's a fact-intensive issue. So under Buzz Stew, the court needs to accept all of the state's allegations as true, factual allegations bearing on this issue. And just to clarify, Buzz Stew would also require the court to conclude that there are no facts for the state that the state could ever discover that would change the court's analysis on this issue. If the court were to find it to not be a product subject to Nevada's product liability laws, under Buzz Stew, the court would accept the state's allegations as true and also take the extra step and say there are no facts the state could ever discover to change the court's analysis of whether TikTok is a product. And I do not believe, I am certainly not savvy in this technology space. So I don't know what facts will be discovered. That's why I suggested maybe expert testimony and evidence would be appropriate for this issue to benefit the court. I don't know what facts we're going to find that might bear on this analysis. And so under Buzz Stew, I just don't, I don't see how the court could say there's no set of facts possible after discovery to support TikTok being a product. And that's why I think the appropriate posture is like Schuler. Summary judgment, parties have had time to do discovery and decided, and then the court has a full factual record before it. And if the state can't develop facts to support it at that point, so be it. But at least the court then knows what it has in front of it. But prognosticating on what facts might be out there in a highly technical space seems like a risky proposition.
My question was more whether you were contending that the Schuler concept doesn't apply to a motion to dismiss, or whether or not you were contending that there was some modification of Schuler that would need to apply in a motion to dismiss, whether you were contending that by definition, a motion to dismiss is not a proper method by which a product's liability case could be disposed of, and somehow somewhat contending that Schuler says affirmatively it's got to be at a summary judgment stage or later that it could not be at a motion to dismiss stage. I wasn't sure if you're making any of those arguments.
No, I don't think I'm going that far and saying Schuler could never be applied at a 12B5 stage, but the Schuler test would have to be applied through the filter of a 12B5 Buzz Stew analysis as well. And I guess one comment on that point, TikTok, and we heard it here today as well, but in its briefing points to other decisions from other courts and other jurisdictions applying different standards of review and different product liability laws. So I don't think that those are the appropriate or even persuasive necessarily for this court. This court needs to apply notice pleading 12B5 Buzz Stew through the Schuler analysis. So hopefully I've clarified that, Your Honor. And one final point I'll make is I heard counsel ask for these claims, including the product liability claims, to be dismissed with prejudice because they're uncurable. I think that ties in with whether there's facts that could be discovered. I don't think with prejudice dismissal would be appropriate when there's a possibility for discovering additional facts that might bear on the Schuler analysis. So I would ask that the court, if it were inclined to dismiss any of these causes of action, do so without prejudice so the state can conduct discovery and revisit the issue if appropriate. Thank you.
Okay. Here's my challenge, folks, and I want to make sure I give TikTok the same amount of time. Remember, this was supposed to be 5 to 7 minutes. I appreciate I've asked questions, so we've gone way past. I also have other people here from my 8:30, which is now 10:30, and I appreciate it. wait, I think they went and came back. So how much time do you really, I'm just trying to balance everybody's needs.
Depending on the court's questions, and I understand you may have some, I don't expect to be very long, like 5 minutes.
Okay, let me let you go. Let's get this, then let's get everyone trying to take care of. Go ahead, please.
All right, Your Honor, let me start with standing and the statutes that are quoted in the first paragraph of the second amended complaint that Mr. Guyan pointed out. Those should be familiar to everyone because those are what we dealt with on the first motion to dismiss. And reading from the order, the state relies on those same 3 statutes discussed above, none of which authorize the state to pursue claims for negligence or unjust enrichment on behalf of Nevadans. These statutes aren't new. This is what the state relied on the first time, and the court said they don't get you where you're trying to go. So what the state now says is, well, in an effort to try and bolster the argument that they're making that standing solves the independent defects with the claims, specifically for negligence and unjust enrichment. Your Honor, I think the argument drives home the problem. Because what they're saying to you is that by saying that we owed a duty of care to the users, that means we automatically or by proxy owed a duty of care to the state. And because the users conferred a benefit on the defendants by proxy, the state has conferred a benefit on us. They run headlong into the primary case they're relying on, the Alfred L. Snap case from the US Supreme Court, which says you have to identify an interest apart from the private individuals you're suing on behalf of. They're confirming for you what we're saying, which is there is no distinction. So, Your Honor, that standing problem still exists. Now, they cite to you a definition of the public interest, and the court asked the appropriate question, is there any Nevada Supreme Court case or Court of Appeals case interpreting that statute? And the answer is no, because we would have given it to you. But let's talk about the Moore case that was cited in the second amended complaint. We talked about that before, Your Honor, the first go round. Remember what Moore is. The AG wanted to step in and set aside a divorce that it believed had been obtained improperly. And it said, we're relying on the predecessor to one of these chapter 228 statutes that the state relies on. We're relying on this in our public interest in marriage to pursue this claim. And the court said, time out. We get that the state may have an interest in marriage, but you don't have an interest to inject yourself into a private relationship and seek to set aside a divorce decree. That too drives home the problem, Your Honor. The private parties that were a part of that marriage, they had the ability to get the divorce. The state doesn't get to step in and say that the divorce decree is in the public interest, so we get to have a say here. The Supreme Court rejected that based on the predecessor to the statute that the state is now relying on. So the same thing applies here. And parenthetically, none of those statutes say anything about pursuing money damages claims. None of them. So, Your Honor, I'll touch on products liability and then I'll sit down because I think I've covered negligence and unjust enrichment and how those same problems still exist. The second amended complaint, yes, it has a number of new allegations. Mr. Guyan cited paragraphs 352 to 377. Take a look at what those are. They are policy arguments. They're analyzing Schuler. They're talking about electricity. They're talking about the definition of item and instrumentality. Your Honor, what Schuler says is you have to determine whether an item or instrumentality is a product. It doesn't say if you're an item or you're an instrumentality, you're ipso facto a product. That's why we're here. Schuler tells us that this is a question of law, Your Honor. They're citing to you these paragraphs. They're talking about BuzzFeed. I heard it 15 times in the response. We all know the BuzzFeed standard. We get it. But what do we also know? The court doesn't have to accept as true legal conclusions that are asserted in the second amended complaint. And that's what's new here, are legal conclusions, not new facts, Judge. So I'll say what I said before in answering the question that the court posed to Mr. Guyan. Whether something is a product is a question of law. The court is perfectly capable of doing the detailed analysis of the policy objectives that underlie products liability doctrine and looking at other precedents, interpreting the restatement, which are the two things Schuler tells you have to do. You're perfectly capable of doing that right now. That claim should be dismissed, Your Honor.
How? Because counsel for plaintiff, right,
Mhm.
articulates that from his client's position, I'd be having to make a resolution of factual determinations contrary to Buzz Stew's statement that the court has to assume, right, that the factual allegations are true. I appreciate you all have a difference of opinion about certain things, whether they're facts in the complaint, whether they're legal conclusions, whether whatever.
Yeah.
They've got paragraph numbers, okay, in the complaint. I think you all can agree on that part of it, right?
I can definitely agree on that part of it, Your Honor. I can agree on something else too.
Go ahead.
And that is that factual allegations that are made in the complaint, and let's just, for the record, there are 431 allegations. So you stand up and you hear Mr. Guyan, who is a very fine attorney, stand up and tell you, this is notice pleading. I don't even know how this works. Judge, how many cases is the state pursuing against these platforms or these defendants that have these online platforms? This is an incredibly detailed complaint, but live by the sword, die by the sword, because when you put it in your complaint, it's a judicial admission. So they've told you how they think this operates. They've told the court in 431 allegations, this is the problem with this platform. So they don't get to, on the other hand, say, whoa, wait a minute, Judge, this is Buzz Stew. We gotta do some discovery and figure all this out. I get that you do, but whether something is a product is a question of law. They've put enough in front of you to make that determination right now.
You want to pause for a second? You can.
And Your Honor, counsel who's involved in some other cases is that the state has also had the ability to do a pre-suit investigation. And that's why the complaint is probably as detailed as it is, because they're not coming to this writing on a blank slate. And I'll leave it at that.
Sure, thank you. I do have to ask you, since you raised that, are you contending that the court can take into account a pre-suit investigation when ruling on a 12B5 motion in the state of Nevada?
I'm just indicating that that is likely why we're able to have a 431 paragraph complaint as opposed to a notice pleading complaint that might be, a quarter of that.
Okay. It seems to me everyone's had lots of time to speak. So everyone think that they didn't have more than their 5 to 7 minutes.
More than fair, Your Honor.
No, Your Honor. Thank you for your patience.
You all probably can appreciate that I'm going to say I need to put this on my chamber's calendar, right? I need to evaluate everything that was said here today, and obviously the excellent pleadings, the excellent oral argument. Realistically, I am gonna have to move this one because I probably appreciate I'm here today. And is anyone contending that the court was not asking fully appropriate questions, or is anyone contending that the fact that my voice is hoarse has anything to do with your ability to get your full and fair hearing today?
No, Your Honor. Not at all.
Absolutely not.
Prepared as always.
No, you know why I'm asking that. I'd rather find out today. Someone's going to raise the issue. Tell me now. But what that's going to mean is you can appreciate a lot of my weekend. Everything was rereading for all of you all. So I'm probably going to. I'm not going to sit here. So when I'm not going to say the 14th, because realistically, to get this and another decision out by the 14th is probably not currently feasible, with the other things on my docket and everything else. So I'm going to put this for Chambers calendar on the 21st. And probably if anybody might be involved in any other cases, you might see a notification that we're moving from the 14th to the 21st in the other case as well. So not anything to do, but that's just a friendly heads up. Okay, that then concludes at least for today. Thank you again, everyone, for everything. And have a great rest of the week.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, Your Honor.
Need to circle back.